Where were we? Prior to the break, it's with great pleasure that I resume some remarks on the Education, Children's Services, Enrolment and Attendance Amendment Bill. As I was describing before, this is a bill that deals with that most important issue of how do we best serve the children in our community by ensuring that our systems, our structures, and the law puts them in the position where they are most likely to attend school. We know that children, of course, have agency in their own lives, and some children who present behaviours or resistance or challenges to getting them to school, their parents have a more challenging circumstance here than other parents. But there is a key question that courts always consider in relation to whether the parents are taking the appropriate steps to get their children to school. We would love every child to be at school every day of the week, every week of the year. But we know there are circumstances where that is not going to be the case. We cannot accept that. We must always be striving to do better. This bill represents, as I was describing earlier, an evolution that has been continuing for some time. When I became the Shadow Minister for Education early in 2016, as it was 2 years prior to the 2018 election, I believe the member for Port Adelaide had been the minister for a little while before I was. But in the 15 to 20 years prior to her assumption to that portfolio, my recollection is that there had been 2 prosecutions only in that whole time for parents who had allowed their children to be truant. As my summary, the description of the offence in the Act is a lot more complex than that. And I recall at the time the debate happening because there was a discussion of a new Education Children's Services Bill, an evolution of which has now become the Act as of the 2019 legislation. And in that bill, there was a number of propositions put forward by the member for Port Adelaide in relation to reform. I'll come to the detail and the specifics later, but the point that I make first is that the resistance from the department and the Department for Public Prosecutions in particular, the Office for the Prosecutor in particular, was that they were concerned that a successful prosecution under the pre-2019 legislation was unlikely. They were concerned that the standard of proof required to be met in order to achieve a guilty verdict was unlikely to be met, and the resources required to establish that proof were also unlikely to be justified according to their KPIs because of the low level of the fine that was in question. I can't remember whether it was $250 or $150, but for the tens of thousands of dollars it would have taken the Crown to prosecute such a case, for the low likelihood they felt of a successful prosecution according to the metrics that they used, that was unfortunately a reason why they said it wasn't good enough. Now, I do want to commend the member for Port Adelaide. I'm going to come to a point of difference in a moment, but only a policy one, to be clear, and one that I think we reached a satisfactory landing on, but that's a later part of the story. But in 2017, I suspect it was, and I imagine that it had been worked on for a little while earlier than that, the member for Port Adelaide as Minister for Education managed to persuade, convince overall or some other effect, get the prosecutors to take 2 cases to court. I won't go through the details of the cases. Every case has a set of stories whereby there is always, when we're talking about children in a vulnerable set of circumstances, or indeed a unique set of circumstances, there's always a story. It can be a very sympathetically told story. But ultimately there are children, I think 3 children, 2 prosecutions from memory, who weren't going to school, who could have been going to school. And despite the low level of penalty on question, despite the high level of resources that it took, the application of that law in those cases, as we were encouraging the government to do, as the minister saw the value in doing, as the minister instructed them to do, was multifold. First and foremost, those kids then, who I checked in on from time to time as the minister in the years subsequent, went to a lot more school than they would have had they not had that court action taken. It also sent a message to a large number of other families. The Department for Education, the government of the day, Liberal Party and the Labor Party, were all interested in whether their children were going to school. It's one thing to have a framework within which we're providing every opportunity for children to get the best outcomes so long as their parents are engaged. But in a circumstance where there's enormous complexity, that sometimes can be complicated. Sometimes getting the parents' attention is actually requires that extra step of prosecution. And certainly that was the case in 2017 under the old law. Now, my recollection in that case was that they were able to identify not just the standard of proof to meet an individual case, but by having a number, I think 10 or 12 cases laid simultaneously, because of course the offence is the number of days left missing from school. And if you're able to establish that a child has missed 10 times that number of days without reason, then you can get 10 counts of the case, and that lifts the penalty. It's not about applying a financial penalty to a family who might have been in a vulnerable situation in one case, who weren't in the other case. It's not about the penalty. The courts apply discretion in such things, not to need to apply the full penalty. It's about ensuring that the attention is made to those children, that the encouragement is joined by the enforcement to get those kids to school, and indeed that other parents can no longer think of their situation thinking, well, they'll never take us to court, it's never going to be an issue. From a policy point of view, it was still seen as desirable by everybody to improve the legislation, because there were complexities in establishing a prosecution that potentially the threshold could have been easier. One of the factors being put forward by the opposition at the time, as we are now, was to substantially increase the level of fine and leave it to the court's discretion to determine what was appropriate. And that has broadly been introduced in the subsequent 2019 legislation. Another proposal was put forward to have expiation notices. That was in the original 2017 bill, and we rejected it. We argued against it in the Parliament, and we rejected it from the ultimate bill. I understand that is still in consideration now, and there are processes taking place. Look, if a bill comes back in the future, bring that forward. It'll be for other minds than mine to consider that aspect. It's not in this bill. The government's decided not to pursue it at this time. For my own point of view, I applaud that. And I encourage anyone interested in the topic to revisit the debates of the time. I think that the whole point about a court being able to apply their discretion to come up with an appropriate penalty, and indeed that you want to do everything you can to work with the family prior to pursuing a prosecution, is potentially lost once you look at an infringement notice, a parking ticket, a speeding fine, if you like, an expiable offence. I'm worried about them being applied too liberally in one sense, but also as a burden in another. So that takes us past the 2018 election. The 29 bill, as it came through, resolved that issue in favour of increasing the fines, allowing the courts to apply their discretion and not having the expiable offence. But I'd highlight one other issue that the 2019 legislation included, and that's this family conferencing system, which has subsequently been used, I think the Minister highlighted in his second reading speech, in 179 children's cases with 122 families. Those are the ones that have been reviewed for prosecution. But without having the stat in front of me in terms of family conferences, I understand it's in the hundreds, or at least over 100. And in those family conferences, it's an education conference. It's similar to the processes used in the youth court, and it fundamentally involves getting a family around the table and establishing what's been going on, what are the challenges, who are the relevant officers of the education department or other government authorities that are relevant, the school and the parents, and seeking to resolve them in a collaborative session. This is something that was first suggested to me when I was a new Shadow Minister in 2016 by a man called Trevor Elburn. Trevor Elburn is many things, and he's been many things. He'd be known to anyone involved in housing policy in South Australia. He's got significant contribution to supporting people downsize into their third stages of life. He's also a musician and a great singer. Trevor Elburn was a truancy officer some decades ago, and he brought forward this idea about how you effectively engage with people, ensuring there's a stick available to encourage them to the family conference, but the purpose of the family conference is to identify how the government and the school or the police or whoever else can best meet the needs of supporting that family for a good outcome for the students. And that made its way into the legislation, which I think the Minister and the Department have been using to great effect. 2019 came along, and I was very much looking forward to then following the lead of the member for Port Adelaide, and I supporting the department in prosecutions, potentially having the services of the Crown give us assistance in securing some positive outcomes and some more kids back to school. Ultimately, that was cut short, as were so many things, by the pandemic. In February 2020, we changed our posture completely from trialling. We had approaches in Port Augusta where we had piloted a new model of advertising and social media and social awareness campaign about getting your kids to school. We had all sorts of exciting collateral developed. I hope that the department's made some use of it in some of the things that the Minister has done in the last couple of years. All of these things, of course, were thrown out of the window when our posture shifted to telling everyone to keep their kids at home if they had the sniffles. It became extraordinarily difficult to determine, from a school's point of view, whether a child was truant when our first order of business was to make sure that they weren't going to make somebody sick by their attendance at school. To the point where you don't need a doctor's appointment to be absent, you need a doctor's appointment to prove that you're not well in some senses. Sorry, to prove that you're well enough to attend. A test to say that you don't have COVID. So, keeping the community safe is a government's first priority in any circumstance. Children attending school is a very, very high priority, but there was a clear and immediate danger to the whole community of any outbreak. There's never been a year in recorded history where so few people have had the flu or the common cold as 2020 was. But it meant that everyone had to stay home. For the rest of the term of the Liberal government, we were unable to pursue any truancy-related policy because from the Term 1, Term 2 holidays, late Term 1 2020, people may recall that we had school attendance in South Australia down to about 65%. Less in some schools, far less in some schools, higher in others, but across the whole state it was about 60%. And that was high by national comparison. I remember coming into Term 2 2020, South Australia, Western Australia and the Northern Territory were the only states encouraging their kids to go back to school. And the Labor ministers in the Northern Territory, Selina Weibo, and the Labor minister in Western Australia, whose name escapes me for a minute, but I suspect she was there before me with the member for Port Adelaide and after me with the member for Wright, the three of us were exchanging messages, competing with each other about who was going to have the higher attendance at school, while hardly anybody was at school in Victoria for 18 months. It was a different set of circumstances, but ultimately it led to the position where we weren't able to pursue that from a policy point of view. The Minister has taken that up since the end of the experience of the pandemic. And I commend the department for that, and I say to him, you're welcome for the preparation that was done. I would highlight that as we seek to further iterate and improve the bill with certainly the in-principle support of the opposition, and I think, we're supporting the bill. There may be some questions to come when we get to the committee stage about detail. This is something that will keep evolving. We are not in a perfect state, and there is no such thing. But we will keep improving this legislation in the years to come. The legal advice that ministers and future ministers will get will inform further improvements to the bill. Also, the challenges are different. When I was the minister, I recall on any given day there were about 9% of kids absent, about 91% attending. And of that 9%, the average would probably be 3% were sick, 3% had a reason, and 3% didn't have a reason. And those 3% that didn't have a reason, or didn't have a reason that would be acceptable, has grown. It grew by about 10% in the years immediately after COVID. There's increases in school refusal, there's increases in anxiety, there's increases in people who are concerned about infectious diseases. That third one has directly informed one of the clauses in this bill that we're dealing with today. So I make the point, some of this bill is further improvement in response to circumstances. Some of this bill is further improvement in response, no doubt, to legal advice, and some of it is related to consideration of policy questions. And those policy questions, I'm sure, will continue in the years ahead. I think as a function of the family conferences working out a way to use that family conference as a mechanism to identify whether or not a family is needing to have a letter of concern, a potential prosecution investigated, is worthwhile. And I think that is clearly incorporated into the bill in the proposed legislation. And I think that in the years ahead, there may be further changes needed. I'm sure the Liberal Party will seek to support those from government, as we will be, and I hope that the Labor Party in opposition will take as constructive an approach to this sort of legislation in the future as we have for this remaining 3 months to 5 months while we're in opposition. With that, I commend the bill. I acknowledge that either the member for Flinders or I, or potentially others, will likely have some questions in committee stage, and I look forward to its further consideration in due course.